Hi, this is Katie Burrows and Eric Valle with PilieroMazza. Thank you all for joining us today. Today we're discussing the 5 W's of bid protests, the who, what, when, where, and why. I'm a partner with the government's contracts practice at PilieroMazza. I actually lead the bid protest practice here. I also handle lots of other matters, external and internal investigations, key TAM suits, federal claims, requests for equitable adjustment, so on and so forth. And I also have with me my colleague, Eric Valle. Eric's practice also primarily focuses on bid protests, along with contract claims and appeals. He also handles many compliance and suspension and debarment issues, FCA claims, and so on and so forth. So we appreciate you all joining us today to learn a little bit more about bid protests. Just a quick little intro about PilieroMazza. We're a full service business law firm. We do serve as strategic partner to government contractors and commercial businesses throughout the United States. We have a litigation group. We have a corporate group, our government contracts group, and also labor and employment group. And as you will see on this slide, we represent clients in numerous areas. So today, what we're going to discuss is, the main topics are: what is a bid protest? Who can file a bid protest? Where you can file? When? Which is always very important, and why you would file a bid protest. So I'm going to turn it over to Eric to start us off on the substantive conversation.
Thanks, Katie, and good afternoon all. Thanks for being here with us today. So we're going to give you, I guess, this is more of like a little crash course in bid protests as we get towards the end of the year and into the next year, and you're thinking about contracts and opportunities to protest. So, with that in mind, we'll start off with what is a bid protest. And a bid protest is a challenge to an agency, a federal agency's actions related to a procurement. There are also state level and local protests that can happen from time to time and are allowed by various state and local regulations and statutes, but we're primarily focused on federal procurement and federal bid protests today. And so, it's important to note that bid protests, as we are discussing them, are different from size or status protests, which are typically handled by the U.S. Small Business Administration. Bid protests are actually just related more to the solicitation itself that the agency releases, and then the evaluation of your proposal or the awardee's proposal or others in the competition, their proposals. When we think about bid protests, we generally classify bid protests into two different categories. The first are pre-award protests, and as the name suggests, these happen before the agency makes an award to a company. And so your typical pre-award protest grounds will be challenges to the terms of the solicitation or challenges to sort of the ground rules of the procurement. And that might be something along the lines of, we think this procurement should be set aside for small businesses, or we think this procurement should be conducted pursuant to a certain statutory regime, or conducted using various procedures in the regulations. Perhaps they're soliciting an IDIQ contract when it should be solicited as a standalone single award contract. Your other typical types of pre-award protests are a little bit akin to a post-award protest, but when you as a company have been removed from or excluded from the competition prior to the agency actually making an award decision. Oftentimes that will come in the forms of like a two-step procurement. You'll be disqualified on the first step, or the agency will sometimes set what is known as a competitive range, and they will exclude various companies from the competitive range and not allow those companies to continue to participate in the procurement and continue to revise their proposal. So those are the pre-award protests that we're generally thinking about. The second broad category of protests are post-award protests. And, as that name also implies, those occur after the agency has made an award of the contract to another company. And so in those scenarios, generally, a company will protest that the agency's evaluation of the company's own proposal was flawed in some manner, and or the agency's evaluation of the awardee's proposal was flawed in some manner. So those are just two kind of general categories to get you thinking about the types of protests that can be filed. Frederick, we'll go to the next slide now. And so, every year the GAO releases some bid protest statistics. We'll get into where you can file protests later, but really the GAO and the Court of Federal Claims handle the same types of arguments. The Court of Federal Claims does not release statistics like GAO does, but GAO will come out with which types of arguments are the most sustained arguments, or the arguments that most often result in GAO recommending that the agency take some sort of action to correct a flaw in the procurement. And so as you all are out there thinking about, am I going to protest, or is this an area where I want to protest? Some of the arguments that should come to your mind, or that you should be on the lookout for in kind of assessing this internally before you reach out to counsel, are unreasonable technical evaluations. So if you believe that the agency assigned weaknesses to your proposal that were undeserved because your proposal perhaps addresses that exact thing that the agency believed to be a weakness, or if the agency failed to assign certain strengths to your proposal that would have increased your evaluation, your technical evaluation rating, those are areas that are often ripe for protest. A second area are flawed discussions. So oftentimes the agency will engage in the discussions process with offerors and identify certain areas of a proposal that could be improved, or certain areas of your price that might, you might want to increase your price or decrease your price. And if those discussions are improper or misleading, or basically entice you to go out and do something that ends up actually resulting in some sort of evaluation or downgrading of your evaluation, a flawed discussions argument might be a ripe protest ground. Another area is an unreasonable cost or price evaluation. This is a generally broad category that GAO puts out there. There are a number of different types of price and cost evaluation methodologies that an agency might utilize in any given procurement. And so, if you think that if there's a cost realism, if the solicitation calls for a cost realism evaluation, and you think that the awardee's price is unrealistically low, that could be a successful protest ground potentially. Conversely, if the solicitation calls for a price reasonableness evaluation and the awardee's price is drastically higher than your price, it might be a ripe protest ground to argue that that price was unreasonably high. And the final of the list of most successful bid protest arguments that GAO puts out are unequal treatment. And so this goes to kind of a fundamental principle of protests, that an agency needs to treat all offers equally, and not hold some offers to a higher standard or a more stringent standard than others. And so oftentimes, as a company first assessing whether you have a protest ground, this one will be tough to see. But as protest counsel gets involved and gets behind a protective order and is able to see the awardee's proposal and the agency's evaluation of the awardee's proposal, an unequal treatment ground might arise. And that what that looks like is, for one example, both you and the awardee offered the same aspect or same solution to a problem. Let's call it solution X, in the exact same words. And the agency assigned the awardee a strength for offering solution X, but did not assign you a strength for offering solution X. Or conversely, the agency assigned you a weakness for proposing solution X and did not assign the awardee a weakness. That's an unequal treatment ground, and we would be able to raise that in a protest. So that's just a brief overview of what a protest is and what some of the most successful protest arguments look like. I'm now going to pass this back over to Katie to get into the next slide.
So the next slide, we deal with who can file a bid protest. And if you're the protester, you must be an interested party. And so for a pre-award protest, you have to be a prospective bidder. And for a post-award protest, you have to be an actual bidder or offerer. So the way that this kind of breaks down is if you lose the award and you want to protest that post-award, say, there were 15 people, 15 offerors, and it turns out that you were, say the agency ranked offerors and you were 8th in the ranking, it's unlikely that you would be considered an interested party because you have to show that, there was a direct economic interest that would be affected by the agency's, unreasonable evaluation or errors. So if you're 8th in line, it's unlikely that it's not impossible, but even if the agency, say, corrected their evaluation errors, if somebody else has got the highest ratings, number 2 person in the ranking has the highest ratings also and a lower price than you, it would be very difficult to get over that hurdle and you wouldn't be considered an interested party. An intervener can also join a protest. So if you are the awardee and you find out that your award has been protested, you have a right to join as an intervener. In a pre-award setting, it's not impossible, but it's very unusual for GAO or the court to allow you to intervene in a pre-award protest situation. So you typically would have to file your own protest in that situation if you think that there's errors in the procurement process or the solicitation. Frederick, you can go, yeah, there we go. Eric, I think you want to continue on there.
Sorry, 3 years into this and I still haven't quite figured out how to use the mute button. So the next question in the sort of primer of bid protests are, well, where can we file a bid protest? And there are really 3 options and a 4th in FAA disputes, not even really an option. So I'll start with the last one. If you have a procurement that is being conducted by the Federal Aviation Administration, those protests will go to the FAA's Office of Dispute Resolution for Acquisitions, known as ODRA. And, we're not really going to get into ODRA procedures or protests today. They're sort of unique in the rules and the procedures that they use. But for all other federal agencies, there are typically 3 protest options. The first is you can protest to the agency itself. And in our practice, we typically will go to the agency when there is a fairly obvious impropriety in the solicitation that the agency is issuing, because we can often get the agency to then just take fairly prompt corrective action and issue an amendment to the solicitation to remove that fairly obvious impropriety. For instance, if the agency has put out a solicitation and they are conducting their procurement using full and open competition, sometimes it might make sense to go to the agency and say to the agency, this is the type of procurement that needs to be set aside for small businesses. Here is the statute that you are violating by issuing this solicitation as a full and open competition, and please go and correct this issue. You can bring other types of protests, post-award and pre-award protests, to the agency. However, we typically find that when you bring a post-award challenge, or if you've been eliminated from a competition and then protest that to the agency, the protest goes to the contracting officer, and the contracting officer is often reluctant to go back and correct a decision that he or she just made, excluding your company from the competition or not selecting your company for award.
I should note, Eric, we should note that you can typically ask for someone above the level above the contracting officer to review the protest, but again, asking the agency to review its own decision. So it's unlikely they're going to find that they acted unreasonably.
Yeah, exactly. It's, there's no set person at any agency that sits in this role at a level above the contracting officer. So, like Katie said, you're going to the agency itself. The agency in the royal form just made the decision, and you're basically telling them that their decision is wrong and asking them to correct it as a result. And just oftentimes they're reluctant to do so unless there's a very clear violation that you can point to. The second option is to go to the U.S. Government Accountability Office, GAO. This has historically been sort of the first step for most protesters, is to go to the GAO. GAO handles a significant number of protests per year. This particular office within GAO, that's all they do are look at procurement protests. And there's a fairly extensive body of case law that GAO has developed over the course of the decades that it has been handling these types of cases, and a fairly stable body of case law as a result to go to GAO. GAO is also required by statute to resolve all protests within 100 days. So there are, typically you can get a more timely resolution of a protest out of GAO than you might get out of the Court of Federal Claims. And in addition, there are some other reasons you might go to GAO, including the statutorily mandated stay of award or performance. And so if you, for example, bring a post-award protest and you file within a certain period of time, the agency is required to not allow its awarded contractor to start beginning performance until GAO resolves the protest. Similarly, if you bring a pre-award protest within a certain period of time, the agency is not allowed to make an award of the contract until GAO resolves the protest. So that's part of the benefit or part of the calculus when deciding to go to GAO. The final option is the U.S. Court of Federal Claims. The Court of Federal Claims is, as you can see, a court, and so there is a little bit more formality to the process than you get at GAO. The court is not obligated, or the agency is not obligated to automatically stay award or performance when the protest is filed with the court. So there is no, at times you would need to fight, or in, I guess, kind of the most common scenario, you would need to fight over whether the court would issue a preliminary injunction if you go to the court, although at times the agency will agree to a voluntary stay until the court resolves the protest. We'll get into a little bit more of the pros and cons of each of these areas later, but you might be asking, well, why would I ever go to the court? The court has, a little bit more, well, number one, the court can issue orders, which GAO can't do. So the court can actually order the agency to take some action instead of recommending some action. And in addition, there are some benefits to the court in terms of the record that you will receive as the protester at the court and the documents you'll have access to at the court. When you file at the GAO, the agency is only required to produce what it deems to be the relevant documents, whereas if you file at the Court of Federal Claims, you get access to all of the documents in the administrative record, which might provide some other bases for protests that you might not otherwise be aware of if you only went to GAO or only saw the documents that were produced at GAO. So those are the three options for filing a protest. We'll get into some of the pros and cons of those various forums later on in this presentation, but those are the options you can go to. And just as a final note, in certain procurements, you can start at GAO, and if you get a decision that's not in your favor, you can file what is commonly referred to as a second bite protest at the Court of Federal Claims, where you ask then the court to review essentially the same protest that you already filed at GAO. And you can't go in reverse. You can't file at the Court of Federal Claims first and then ask the GAO to review the same protest. You would be untimely at that point. And with that, I will turn it over to Katie for the next slide.
So this goes to the when, as Eric was kind of just referring to. So this is kind of where the rubber meets the road, and where we really find that clients or contractors can get into trouble because they wait too long to contact counsel for various reasons, which we'll go into a little bit. But so for pre-award protests, I think Eric had mentioned this earlier, but you have to file a pre-award protest before the date set for receipt of initial proposals or quotes. And if there is an amendment that say was issued after that, that changes the solicitation in some form, then you would have to file it before the next closing date for receipt of proposals. So a common mistake is waiting until after award to raise these pre-award issues. And you'll see on this slide some examples of these issues that you cannot wait to file until post-award are improper or unclear solicitation terms. So if you find that there's a solicitation term that is ambiguous on its face, you need to file that pre-award. Now, if it turns out that there was some latent ambiguity that isn't realized until after award, you can file a latent ambiguity claim then. But for anything that's patently obvious, you have to file that prior to submission of your quote. And then if a solicitation limits competition, for various reasons, there is a provision that's included in the solicitation that unduly limits competition. You would need to file that protest pre-award as well. If you believe that, say the rule of two should be applied and the procurement should be a set aside for, say, SDVOSBs or small businesses, things of that nature, you have to also protest those issues pre-award. And then exclusion from the competitive range, you need to file within 10 days typically, well, I should say after assuming that you request a pre-award debriefing we'll get into that a little bit later. But those are some of the issues that pre-award protests, if you wait until after award, you are going to be found most likely untimely. So Frederick can go to the next slide. So a couple other examples of pre-award protests, say the agency issues an amendment and it's a substantive amendment and they give you, 24 hours to, submit your proposal, or say they give you 24 hours to submit a revised final proposal. You could protest that on the basis that the agency didn't give sufficient time to prepare and submit the proposal. Organizational conflicts of interest often have to be filed pre-award, not always, but it's if there's information that you have that would lead you to believe that there's a conflict of interest, you should definitely look into or talk to counsel about whether that needs to be filed pre-award. You can also protest the cancellation of a solicitation. Generally, the agency has pretty wide discretion in canceling a solicitation, but there are instances in which you could succeed on that type of a protest. And then another one, these are all issues with the solicitation, the inclusion or exclusion of certain FAR clauses. So if there are certain FAR clauses that you think should or should not be included in the solicitation for various reasons, you'd need to protest that pre-award as well. And an important thing to note for pre-award protests is that when you file a pre-award protest, the agency can't award the contract until the pre-award protest is resolved, but it can continue to evaluate proposals or quotes pending resolution of the protest. So, and then a lot of, a question we often get asked is, if I file a pre-award protest, can I, do I have to submit my proposal? And in almost all instances, the answer is yes, because going back to that interested party discussion we had a little while ago, if you don't submit your proposal, you're unlikely to be considered an interested party for purposes of the protest, and so you would likely get kicked out. So let's see, Frederick, you can go on to the next slide. So post-award protests, the timing does change depending on the forum. The agency and GAO, it's 10 days from when you knew or should have known of the basis for protest. At the Court of Federal Claims, there is no set deadline for filing, but you should file sooner rather than later. It is possible you could get kicked out for waiting too long. It doesn't happen too often, but it does happen. And then ODRA, you only have 7 days of when you knew or should have known of the basis of protest, or 5 days after your debriefing. And there's a couple kind of qualifiers here for when you have to file a post-award protest, depending on the type of solicitation that you have. So if it's a FAR Part 15 procurement, you're entitled to a debriefing. If you timely request that debriefing, then they are required to give it to you. So in a post-award situation, if you timely request a debriefing within 3 days of the notice of award, then again, you're required to receive that debriefing, and you are not permitted to file your protest until after you receive that debriefing. And then you would have 5 days to file at GAO to get the automatic stay of performance, or 10 days to be timely at GAO. Same, with the agency. And then again, the Court of Federal Claims, there's no specific deadlines there. One thing to note is we often ask, in a pre-award situation, say it's a FAR Part 15 procurement, and the agency will give you an opportunity to request a debriefing, and they'll give you the opportunity to request a pre-award debriefing or wait until post-award. And they'll often say, well, if you wait until post-award, we're required to give you more information than we would at pre-award. But if you wait to get that post-award debriefing, you're likely going to be found untimely at GAO or the agency, because you are required to diligently pursue your rights, and you can't just push that off. So in a pre-award situation, if you get excluded, you should always ask for a pre-award debriefing. And then the other thing to note, I just was talking about FAR Part 15 procurements, but for instance, for FAR Part 8 procurements, you're going to not be entitled to a debriefing, but you're going to be entitled to a brief explanation of award. And there's a lot less information that the agency is required to give you. And the protest filing deadline for purposes of the automatic stay at GAO and the agency are keyed off of 10 days from award. Now, you could still be timely, say you don't get that brief explanation until day 11. You would have 10 days from that date of receiving the brief explanation to timely file your protest at the GAO or at the agency, but you would not be entitled to the automatic stay. So, you may at that point decide you want to file at COFC, and there's, different factors that we would walk through to make a decision as to whether or not it makes sense, or even if you're permitted to file at COFC, because there are some limitations there. So just kind of a few things to keep in mind. So, it is really important to reach out to counsel once you receive the notice of award, so counsel can help you determine whether or not a debriefing or a brief explanation is you're entitled to, and what the filing deadlines are going to be for purposes of both the automatic stay or just timeliness of filing the protest in general. And so, the sooner you reach out to counsel, the better it is, because these are very tight timelines, and it's often a lot of work that goes into filing a protest and preparing it, both on the contractor side and on counsel side. So the sooner the better. And then you can also, discuss which form may be best depending on the issues that you want to bring up in the protest. And then, of course, calculating the right deadline is key. Frederick, you can move on to the next slide here. So a couple examples of post-award protests. The agency failed to evaluate, your proposal in accordance with the, RFP stated evaluate, or the RFQ stated evaluation criteria. So the agency is required to evaluate proposals or quotes pursuant to the criteria set forth in the solicitation. There are some caveats to that, but typically that is a very typical protest ground. As Eric had talked about earlier, treating offers unequally, and with price realism, again, that goes to kind of the price or cost evaluation requirements of the solicitation. If there's a price realism requirement, the agency can't just ignore that. They do have to do the price realism analysis or cost realism. Standard in almost all bid protests post-award are, to the extent their best value procurements are that the best value decision was flawed. It could be for various reasons. The standard is because of the underlying evaluation was flawed, but it might also be because the agency didn't perform, the trade-offs required in a best value procurement, or that the agency treated the procurement as a lowest price technically acceptable procurement where it wasn't. And then another, typical post-award protest ground is, inadequate, unequal, or misleading discussions, which Eric touched on earlier as well. So the agency is required to treat offers equally when they enter into discussions. And those discussions also have to be meaningful. And there's a lot of case law that surrounds that. Again, these are all things that council can help, you dive into and determine what the best strategy and approach is, depending on the issues that, you believe occurred in the procurement or the evaluation. And then, as far as the best arguments, the ones that are most successful are these black and white issues, that process flaws, things of that nature, where they're, say you're going before GAO, GAO doesn't really need to act, it won't act as like in technical, it doesn't have the technical expertise that the agency has, so it's not going to put itself in place of the agency to make a lot of those technical determinations. So it's a lot easier to win if you have a more black and white issue, like, the agency says, they gave you a weakness because you didn't include X in your proposal, and you can show that in fact you did include X in your proposal, the agency just missed it. Those types of things are easier to win on. And all right, turn it over to Eric if you want to talk about some of the recent case law that's come out.
Yeah, thanks, Katie. Given that this is a primer, we didn't want to get too deep into the case law, but there have been some, relatively significant developments recently. So it's worth touching briefly on just two cases out of the Federal Circuit on when to file a protest. So the first case we want to go into is NECA. And in NECA, we got some clarity surrounding DoD's enhanced debriefing rule. So if you ever have a DoD procurement, you'll be entitled to an enhanced debriefing, and this case kind of clarifies those deadlines that you need to follow. So, by statute, protesters are entitled to an automatic stay of the award or of performance if they file a protest at GAO within 10 days of contract award or within 5 days after the debriefing date that is offered for any debriefing that is requested and required. And that automatic stay, like we discussed before, is kind of one of the most important reasons a protester would choose to protest at GAO over going to the Court of Federal Claims. In certain DoD procurements, however, there's another statute that provides that the debriefing shall include an opportunity for a disappointed offer to submit within 2 business days after receiving a post-award debriefing additional questions related to that debriefing. And so the interplay between those two statutes, the automatic stay statute and the enhanced debriefing statute, had created some confusion. In particular, protesters were a little bit confused. Does the 5-day period to get the automatic stay start running when I receive my debriefing, or does it start running after that 2-day period in which I have to ask questions elapses? And so in NECA, the Federal Circuit resolved this issue. And so NECA was an unsuccessful offer. And on March 4th, the agency sent NECA their written debriefing and alerted them of their right to submit additional questions. But NECA did not submit any additional questions within that 2-day window. And then 6 days after they received the written debriefing on March 10th, they filed a protest at GAO. GAO denied the stay. And then NECA filed an action at the Court of Federal Claims regarding the automatic stay. And the court agreed with NECA, essentially holding that the debriefing period doesn't conclude until the end of that 2nd day, and NECA's protest was timely and it was entitled to the stay. But on appeal, the Federal Circuit disagreed, and the circuit held that the plain meaning of that statute is that the deadline is 5 days after receipt of the debriefing. And in other words, the debriefing is not automatically held open for that additional 2-day period. In order to get that debriefing period held open, you need to submit questions, and then the debriefing will not be concluded until the agency provides written responses to that question. So by implication, when there were no additional questions submitted, as there were in NECA, the debriefing period is not held open. It concludes at the end of that 5-day period after you get your written debriefing. So it's a pretty clear-cut decision at the end of the day, but helped to clarify just some interplay between two statutes that had created a little bit of confusion on protesters' parts up until that point in time. Frederick, you can go to the next slide. And so the next case is Harmonia, and Harmonia deals with the blue and gold line of cases. And so if you've been in the protest world for a period of time, blue and gold is a pretty significant case that came out of the Federal Circuit some time ago. In blue and gold, the Federal Circuit held that a party who has the opportunity to object to the terms of a solicitation that contains an obvious error, but fails to do so prior to the close of the bidding process, waives its ability to raise that same objection in a bid protest at the Court of Federal Claims later on down the road. And the purpose of that blue and gold waiver rule, as we've come to know it, was to prevent a bidder who is aware of some solicitation error from kind of lying in wait to bring its challenge after the award has been made and after it finds out it's not successful, to just sort of restart this bidding process, and oftentimes with increased knowledge of what its competitors have already proposed at that point. So it's a rule that has a lot of general practicality to it. We don't want to delay procurements. We don't want to give anyone an unfair advantage. And if you are aware or should be aware of some solicitation defect, you should have a certain period of time within which to bring that challenge. You can't just sort of wait until the end of this whole process goes through and restart things. In some subsequent cases, however, the Federal Circuit and the Court of Federal Claims have greatly expanded blue and gold, the holding of blue and gold, finding that there are all types of various challenges that can be waived according to this line of precedent. But in Harmonia, the Federal Circuit kind of walked that back a little bit. The Federal Circuit held that a timely filed pre-award agency level protest will preserve your ability to later file that same protest post-award with the Court of Federal Claims. And in this decision, the dates are a little bit important. So on July 12th, the agency issued a solicitation. On October 26th and then November 1st, the agency issued 2 amendments, Amendment 9 and Amendment 10 to that solicitation. And offerers were required to submit revised proposals in response to those amendments by November 13th, just a few weeks later. A day before the proposals were due, Harmonia submitted this pre-award agency level protest. And the next day, like Katie explained earlier, Harmonia submitted their proposal to the agency, timely submitted that proposal. So about a month later, the agency denied Harmonia's pre-award protest. And then about 5 months after that, the agency informed Harmonia that they were not the successful offerer and that another company had won the contract. So just about 2 weeks after receiving that decision, Harmonia filed a protest at the Court of Federal Claims. This was 5 months or about 5 or 6 months after their pre-award protest was denied and they took no action. They filed a protest with the Court of Federal Claims and they raised the same issues that they had raised in the pre-award protest that was denied at the agency level. The court denied the protest and they found that the issues Harmonia raised in the pre-award protest were waived for timeliness, relying on blue and gold and some various other decisions out of the Court of Federal or out of the Federal Circuit and Court of Federal Claims. When Harmonia appealed, they argued that the court had improperly extended blue and gold by finding waiver, even though Harmonia kind of preserved its challenge by filing this pre-award protest. And the Federal Circuit agreed with Harmonia. The Federal Circuit held that Harmonia's undisputedly timely formal challenge of the solicitation before the agency removes the case from the blue and gold waiver rule. And so this kind of gives offerors a set point in time to where you can preserve a challenge and then take that challenge up on in another protest to the Court of Federal Claims should the agency deny your protest. But an interesting and kind of significant portion of this as well, that protest may be timely or the court won't kick your protest out for according to the blue and gold waiver rule. The Federal Circuit held that the opinion should not be read as condoning delay in filing actions at the Court of Federal Claims, and the court has broad authority to fashion a remedy, including awarding any relief they consider proper. On remand, the court might decide under the circumstances of this case that injunctive relief is not appropriate. And so what the court is saying is that, well, the delay won't automatically result in you having waived your protest grounds in the future in this particular situation. That delay may impact your ability to get meaningful relief, or what the court calls injunctive relief, requiring the agency to go back and revise its solicitation and seek revised proposals. The court can decide that your delay has basically prejudiced your right to obtain injunctive relief, and the relief you get might not be as meaningful as you would otherwise get if you brought your protest in a more timely fashion from the agency level to the court itself. So those are just a couple of the cases that have kind of been significant over the past year or two on the timeliness issue that we thought we'd bring up. And so with that, I'm going to turn it back over to Katie. Oh, I think this one's mine as well. Sorry, Katie. So just now we're going to get into the why would you file a bid protest. There are countless reasons why you might choose to file a bid protest. You know, I kind of want to start with the bottom of this slide. So an important thing that I think we always tell our clients to consider is that bid protests can be perceived as having an impact on your relationship with your customer. A bid protest is a pretty unique process in that it does not occur. It is not a process that exists in the commercial or private world. At no point can you look at your commercial customer and say, I think you made an error in awarding this contract to my competitor, and you need to go take a second look at this and give me the award. So customers can or clients can oftentimes view the protest process as sort of poking the government agency in the eye, and the government agency being the customer that you actually want to work with for the next however long the contract exists. So that's an important consideration. We tend to find that agencies don't generally feel that way when they get a protest. We tend to find that agencies are pretty familiar with the protest process. They understand that it's kind of just part of doing business as a government agency. And with experienced protest counsel, you'll find that we craft protests in a way that does not attempt to poke the customer in the eye and use strong language to say the agency is wrong and there's absolutely no way they could have come to this decision. They're a little more artfully crafted than that. But this is nevertheless an important consideration to think of, as some protest issues will kind of just naturally progress towards that kind of finger pointing at that point. So that might be a reason why you would not file a protest. Why you might file a protest, some questions to consider, are you the incumbent? As the incumbent, you might feel that you're better positioned to receive the next award, the award of the follow-on contract, than someone else who doesn't have the same experience. And you might file a protest strategically as well, because getting that stay of performance while the GAO assesses your protest or evaluates the protest, or getting a voluntary stay or injunctive relief, preliminary injunctive relief while the Court of Federal Claims evaluates a protest, will generally entitle you to some extra time. You might get a bridge contract that might result in another 3 to 4 months of performance, and that could be, a benefit to filing a protest, in addition to the hopes of succeeding on the protest and actually getting some sort of corrective action that results in you obtaining the contract. Another question to ask, is your price lower than the awardee's price, or are your ratings better than the awardee's ratings? So this gets back to a point Katie raised before about sort of, are you an interested party? Can you establish prejudice in the protest? The more equal that your ratings are to the awardee's ratings, the greater likelihood, in any given case, that you have of succeeding on the protest, because generally there is less you would need to show, or less you would need to be correct about, to get GAO or the Court of Federal Claims to agree that the mistakes the agency made in evaluating your proposal or in evaluating the awardee's proposal were significant, and had they been corrected, would have resulted in a new award decision, or potentially resulted in a new award decision. So, if you're very far off, if you're lower in all evaluation factors, lower rated in all evaluation factors, and higher priced than the awardee, you have a more of an uphill battle to fight against. You would need to raise each one of those ratings up and knock the awardee's ratings down, and potentially identify some flaw in the price evaluation to stand a chance of demonstrating prejudice and getting some meaningful corrective action. If you're closer, all you need to do is show maybe that one rating was wrong, or that one mistake could have changed something. And so those questions might help influence your protest decision. And then, did you make an obvious mistake in your proposal? That's often a tough pill to swallow. There's a lot of time and effort that you put into preparing proposals, but mistakes happen from time to time. And when they happen, if the agency correctly identified that was a mistake, and we don't see a basis for reopening discussions or engaging in clarifications to correct that mistake, it might be worth chalking that up as a loss, and dedicating some resources to how you can do things better in the future. If there's no obvious mistake in your proposal, if you think that the agency was just wrong in their assessment of your proposal, that's something that would factor in favor of filing a protest. And so really all of this is what is the factual support for these arguments that we're going to make, and how do these things factor into our competitive standing or our chances of success in the protest going forward. And that's something that experienced protest counsel can help you address, but it's something that you can also kind of take a first look at and consider when making the calculus or doing the decision of whether or not you should protest. And with that, I'm going to kick this over to Katie.
Okay, so suspending contract performance, we did talk about this a little bit, but suspension at the agency or GAO level will occur automatically within 10 days of award if you file the protest within 10 days of award, or 5 days after required post-award debriefing. Not all types of procurements necessitate a required post-award debriefing. FAR Part 8 procurements don't, for instance. FAR Part 15 procurements do. So it is important to know whether or not you're entitled to a post-award debriefing as opposed to a brief explanation of award. But if you are entitled and have timely requested the post-award debriefing, then you would be able to file 5 days after that post-award debriefing. And that's with the caveat that I mentioned earlier. If you get kicked out of the competition, you should request a pre-award debriefing, and then your filing deadline would be keyed off of that. And then the agency can override the automatic stay, but it is really unusual. It does happen, but it is fairly unusual. And then if they do override the stay, you could protest that as well. And that's a discussion for another day, but that is possible. At the Court of Federal Claims, as Eric had mentioned earlier, there is no automatic stay of performance like there is at GAO or at the agency. Often DOJ will agree to voluntarily stay performance or stay award, but sometimes you do need to file a request for a preliminary injunction or temporary restraining order to get that voluntary stay or get that stay of performance. But again, we do see often that the Department of Justice does voluntarily stay performance of the contract when you file at the Court of Federal Claims. And just to caveat too, the Court of Federal Claims, the agency is going to be represented by the Department of Justice, whereas at the agency and GAO level, it's going to be represented by agency counsel, just something to note. And then at ODRA, it's almost impossible to suspend the contract. So Frederick, you can go on to 18. I know we're starting to run out of time here. So agency level protests, they can be less adversarial. That goes to Eric's point earlier about whether or not you're going to kind of ruffle the feathers of the agency and impact your relationship with the agency. Oftentimes filing an agency level protest won't have that same visual effect because it's not public. So that may be a reason to file at the agency, you know, depending on what the concerns are. There is also an automatic suspension, as we mentioned before. And one of the benefits of the agency, potential benefits, is that there's typically a 35-day resolution period. So once you file that protest, the agency typically has 35 days to make a decision on it. And they're going to be less costly at the agency level as well, because there's just a lot less involvement. After you basically just file the protest and then you wait for a decision. The agency is not going to produce documents. There's not going to be an intervener there, or at least most likely there won't be an intervener. Typically agencies don't permit it. And there's, you know, they're not going to produce an agency report or anything of that nature like they would at the Government Accountability Office, or, you know, at the Court of Federal Claims, where they would produce the administrative record. So it's a much more compact process. Some of the cons of an agency level protest is that, as Eric mentioned earlier as well, it's not going to be reviewed by a neutral third party. Even if you do request a review above the contracting officer, it's still the agency that's reviewing its own decisions. And con, like I mentioned, you're not going to get any documents produced by the agency in an agency level protest. So you're not going to discover any supplemental grounds per se. And depending on where you sit, a shorter duration of the contract suspension may be a negative if you're the incumbent looking at a bridge contract. Frederick, you can go to the next slide. And then GAO protests, like filing at the agency, one of the benefits is that you do get that automatic stay of performance. And it is the only forum for IDIQ task order protests. There are situations in which you may not be able to protest a task order issued under an IDIQ contract, and DoD procurements. If the overarching vehicle was issued by the Department of Defense, then you're going to be unable to protest decisions where the task order is valued at less than 25 million. and in civilian situations where the overarching IDIQ was issued by a civilian agency, you're not going to be able to protest if the task order value is less than 10 million. Just something to keep in mind. The resolution, GAO's timeline for resolving protests is 100 days. So they have to give a decision within 100 days. And if it does go all the way to the end, say, the agency is not taking corrective action, so GAO does have to make a decision on the protest, it typically goes pretty close to that 100 days. They might issue a decision a couple days ahead of time, but it's not typical that it would be much in advance of that 100-day deadline. And GAO protests are less formal and less costly than the Court of Federal Claims. They're more costly and more complicated than agency level protests, but they are less costly than the Court of Federal Claims. And then some of the negatives for GAO protests, there are very strict deadlines, same with the agency. So again, it's really important to contact counsel. Once you get that elimination from the competition, or you realize that there's an ambiguity in the solicitation or something of that nature, or that you think that the agency's award decision was wrong. And statistically, GAO protests are decided in favor of the agency. That's the same at the Court of Federal Claims as well, and the agency for that matter. But those statistics are a little bit confusing, however, because the agency does often take corrective action as a result of a GAO protest or a Court of Federal Claims protest. So really, when we're talking about statistics decidedly in favor of the agency, we're really talking about when the protest goes all the way to the end and GAO is issuing a decision on the merits. Discovery is more limited at GAO than at the Court of Federal Claims, and Eric discussed that earlier. You're going to get a much more a fuller record at the Court of Federal Claims. You'll typically get the entire administrative record, whereas at the Government Accountability Office, the agency is typically going to only produce those documents that are specifically relevant to your protest grounds, and many of those documents may be redacted. And GAO only makes recommendations to the agency. So if the protest is sustained at GAO, it recommends the agency what it should do, but the agency isn't required to do that. Now, it's very unusual that the agency wouldn't move ahead with whatever GAO recommends for various reasons, but you would have to go up to Congress to address it. There would be some questions there, but nevertheless, it is possible that the agency doesn't follow GAO's recommendation. And then Eric, I think you're on the next slide.
Yeah, and I see we're already at about 5 minutes over, so I'll go quickly here, even though this is my favorite topic, COPC protest. So, the pros, as you can see here on the screen, it's, a little more forgiving on the deadlines because the court is not bound by the 100-day timeline. There is more comprehensive discovery, and we've actually seen in some recent cases out of the court that more comprehensive discovery come to light in second bite protests, where the protester did not have access to certain records during the GAO protest, gained access to certain records as part of their second bite protest to the Court of Federal Claims, and ended up winning the protest based on information that they discovered in the more comprehensive set of documents that the agency needed to provide as part of the Court of Federal Claims protest. As Katie mentioned, the agency is represented by the Department of Justice at the Court of Federal Claims. Sometimes this is a pro, sometimes it's a con. It just sort of depends on the kind of drawl that you get at that point. But I don't think there's any real way to predict one way or the other how that's going to shake out. And then the potential to obtain a permanent injunction. Again, this just differs from GAO in that the court is not going to, make a recommendation to an agency. It is going to issue an order and that order is usually in the form of a permanent injunction if you win the protest. The cons, as Katie mentioned, there's no automatic stay of performance. So you may have to fight a sort of mini battle over whether you are entitled to a preliminary injunction. And one of those factors is likelihood of success on the merits. So it is truly almost a mini trial of the merits of the protest itself. But like Katie has said, we've all seen more recently that the Department of Justice is convincing the agencies, or perhaps the other way around, to go in the voluntary stay route, give a stay of performance or award until the court resolves the protest. And then, like Katie said, the Court of Federal Claims route is generally more expensive than GAO protests historically, mainly due to the fact that there is generally an oral argument, and that is just a little more resource intensive than a GAO hearing, which just generally does not have any oral argument aspect to it. With that, we've concluded the slides. I do want to take a moment to just address one question, and I'll ask this question, Katie, if you want to weigh in. Someone asked, can you address whether a contractor is able to collect protest costs if the protest is decided in their favor?
So the answer is yes. It is possible to be awarded costs if your protest is sustained. That's typically the case, and then you would have 60 days to file your claim for costs with the agency, and hopefully come to some agreement on that. But there are some kind of caveats to the ability to collect protest costs. If the agency takes corrective action before its deadline, and when I'm talking about protest costs, I'm talking about the Government Accountability Office here. So a GAO, if the agency takes corrective action prior to filing its agency report, you're not going to be able to collect protest costs. GAO, there's a whole slew of case law out there that if the agency takes corrective action in that first 30 days, you're not going to get those costs. And then if your protest is sustained, you're only going to get protest costs for those grounds that were successful. So that can be a little bit of a tricky exercise, but it is certainly, we've gotten costs for our clients in the past. Sometimes they've been in full if the protest was sustained in full, and then other times they've been more limited, or in certain circumstances it hasn't made sense. The cost to pursue the claim for costs is more costly than what would have been received, if you're only sustained on a very limited issue that, say, was, a minimal expense compared to the entire cost of the protest. So, and then Eric, do you want to talk about costs at COFC?
Yeah, so at COFC, there's another statute, the Equal Access to Justice Act, EJA, that allows protesters to recover fees in certain circumstances. Those fees it's often an uphill battle to win those disputes over costs there, because you have to be basically the agency had to take a substantially unreasonable position in defending its procurement or award decision. And then even if they did, those fees are further limited by certain tests of reasonableness. But it's something that just sort of needs to be evaluated on a case-by-case basis at the end of the protest. If you're in that situation, you're in a very good situation anyway, because you've already won the protest and hopefully obtained some meaningful relief. And so, while we understand that the costs of protests are often significant, recovering costs are a little bit of icing on the cake at that point, because generally been given another chance at receiving the award, which is generally the bigger battle that you want to accomplish. But yeah, I would just say generally it is a possibility to obtain those costs at the Court of Federal Claims, although there are certain limiting circumstances that may make it such that you can't obtain the costs, or make it such that the sort of cost benefit analysis of trying to obtain those costs doesn't quite, shake out in your favor in all cases. And with that, I don't see any more questions that have come in. If you have any questions, please feel free to reach out to Katie or myself or anyone at PilieroMazza, and we'd be happy to address those questions with you and any of your protests or other concerns that you have.
Yeah, we appreciate all your time. Thanks so much.